Mr. Attaway.
Where is Barrister Chooks?
It's mute.
Maybe he's counting that new currency. Don't mind him.
Good afternoon, my lord.
Yes, Mr. Attaway. Good morning. Yes. Good morning. How are you?
My lord, I just
you're counting the new notes?
Yes. Chooks, I've already exposed you to my lord, so don't tell any lie.
Good afternoon, my lord. I'm sorry, my
Thank
network
you.
wasn't audible.
Okay.
Please to announce myself for the applicant, sir. I'm
Okay.
sorry, I'm coming in a bit offline.
Okay.
With the greatest respect to my lord,
Yes.
I apply for the respondents, my lord. Idigbe Bola Idigbe is my name, sir.
Okay.
Greatest respect, sir.
Yes, my lord, sir. Chukuyem Atewe.
Yes. For judgment creators applicants.
For the judgment creditor applicants.
Yes. Are they in court?
No.
Yeah, no. My apologies, my lords. We all find ourselves in different locations at this point in time, sir.
Okay.
But I did say that I'll still get in touch.
Yes. So this is my short ruling. So by a motion on notice dated 15th of October 2021 and filed on 2nd October 2021, the applicants pray for the following orders. Number one, an order of committal for contempt of court by this honorable court against the second judgment debtor respondent by committing to prison the chairman of the military pension board, who is the principal officer of the second judgment debtor respondent, for failure to comply with the judgment of this honorable court delivered on the 18th of January 2018 and directed against the second judgment debtor respondent. Number two, an order, any other order or orders this honorable court may deem fit to make in the circumstance. Counsels the judgment creditors applicant file the grounds of his application and a 16-paragraph affidavit in support of the same. Counsel also attached 4 exhibits and file a written address to accompany the application. Applicants have filed in the grounds of the application the affidavit in support that this court has the jurisdiction, has the power to enforce its judgment and commit for contempt any person or organization who commits acts which, in the opinion of the court, constitutes contempt of court. It was also about that the judgment of this court was delivered on the 18th of January 2018, directing the defendant, particularly the second defendant, to calculate and continue to pay the claimant judgment creditors, applicants, their pension on the basis of their annual terminal basic salaries of a major general in accordance with the terms and conditions for officers, Nigerian Army, 1979. That despite several demands by the judgment creditors applicants, judgment debtors respondents have neglected, refused, and failed to comply with the judgment of this court. Applicants also stated that judgment debtors respondents have been served with forms 48 and 49, with notice of consequence of discontinuance of court order, a notice to show cause why order of attachment should not be made, which the judgment debtors have failed to respond to before the court. The failure of the judgment debtors respondent to comply with the judgment of this honorable court amounts to contempt of court. The counsel filed a written address wherein he raised one issue for termination to it. And I quote, whether the judgment creditors applicants are entitled to the grant of this application. Unquote. Counsel referred to the provisions of Section 10 of the National Industrial Court Act and Order 47, Rule 7, and 25 of the rules of this honorable court to argue that the court can grant the order for contempt being sought. It was also argued that the judgment debtors respondents have failed to adhere to the judgment of this honorable court delivered on 18th of January 2018, despite being served with the order made a letter of demand of compliance, exhibits MO1 and MO4. Counsel submitted that the applicants have satisfied the condition precedent to the instant application by serving forms 48 and 49 on the respondents. This submission of counsel that by the provision of Section 2873 of the 1999 Constitution, the decision of this honorable court and all other courts established by this Constitution shall be enforced in any part of the or in any part of the Federation by the authorities and persons and by other courts of law with subordinate jurisdiction to this court, citing the case of Ingeri and Okuricate. Citation given. Counsel contended that the law is stated that an action brought upon a judgment is an invocation of the coercive powers of the court to enforce the orders in the judgment. That a judgment of a cause subsists in perpetuity, notwithstanding any error in law or fact therein, until unless it is set aside or vacated by the court of competent jurisdiction. Such in the case of Purification Technique, Nigeria Limited, and Jibril, Nigerian Merchants Navy SSA, and Ocean Fisheries. The counsel urged this honorable court to grant leave for committal order against the chairman of the second judgment debtor respondent, who is the principal officer of the second judgment debtor respondent, by committing him to prison for failure to comply with the judgment of this honorable court delivered on the 18th of January 2018. In opposition to the application, judgment debtors respondent filed an 18-paragraph counter affidavit deposed to by Joseph Adoyi, litigation clerk in the legal department of the Ministry of Defense, on 24th of June 2022. A written address was also filed to accompany the counter affidavit. It was stated in the respondent's counter affidavit that the respondents are not in contempt of this honorable court, as the judgment of this court delivered on the 18th of January 2018 is the subject of appeal at the Court of Appeal Lagos Division. The respondents have decided to exercise their right of appeal against judgment on the 17th of December 2018. It is also stated by the respondent that the record of the court was compiled and transmitted to the Court of Appeal, and the appeal has been entered and appeal number given. Respondents also avowed that there was a chance of succeeding at the Court of Appeal, and it will be difficult for them to recover any payment that may be made to the applicant if they are paid in line with the judgment of this court. Respondents also filed further affidavit on the 26th of June 2022 and attached a copy of a motion with the proposed notice of appeal as exhibit MPB1. Counsel for the respondent in his written address raised one issue for termination to it, and I quote, whether in the circumstances of this case, judgment debtors respondents can rightly be said to be in contempt of in contempt to prison, and unquote. The counsel argued that the answer to the above question is undoubtedly in the negative. That is not in doubt that judgment which judgment debtors are said to be in contempt of is on appeal at the Court of Appeal, Lagos Division, as evidenced by exhibit MPB1 attached to the further affidavit. Counsel also argued that the law is settled that a party to an action who is dissatisfied with any finding of the court has the right to appeal against same, such in the case of Ajibola and Salawuddin. That the respondents have filed notice of appeal in line with the constitutionally guaranteed right to justice and fair hearing, and did not stop at just filing exhibit MPB1, but took steps to ensure that the record of appeal was duly complied and transmitted to the Court of Appeal, where the appeal was entered, an appeal number given as CA/L/153/4M/18. Counsel submitted that the case of Teogbade and government of Oyo State, cited by the applicants, is distinguishable from the case on hand, because in that case, the order was for the judgment debtor to pay to the judgment creditor the judgment debt pending appeal. But in the case at hand, what the judgment creditors applicants seek is an order of committal of the chairman of the second judgment debtor respondent to prison. And the effect of such an order is the denial of the inalienable right to the freedom of movement of the chairman of the second judgment debtor respondent. It was further argued that the grant of the order which the judgment creditors applicants seek in the face of a pending appeal, whatever likelihood of success, will no doubt occasion an incurable injustice against the chairman of the second judgment debtor respondent if, at the end of the appeal, judgment of this court is set aside. Counsel submitted that it is in order to avoid the incurable and irremediable injustice against an innocent citizen contemplated above, that the Court of Appeal held in the case of AG Edo State and Churchgate Industries Limited, that when a person is challenging an order of court by way of an appeal or application, he cannot be proceeded against for not complying with the said order. Citing also the case of Group Danone and Voltic Nigeria Limited. It was strongly contended by counsel that granting an order of committal against the chairman of the second judgment debtor respondent will not serve the interest of justice and will foist on the Court of Appeal a situation of complete helplessness or render negatory the judgment of the Court of Appeal and making the success of the judgment debtor's respondents meaningless and a total waste of time. In response to the counter affidavit, judgment creditors applicants filed a reply and written address on the 11th of November 2022, wherein another issue for termination was raised to it, and I quote, whether the applicant has made out a case to be entitled to exercise the court's discretion in the grant of this application, unquote. The other counsel submitted that the instant application is predicated upon the final judgment of the National Industrial Corbillary or committal proceedings against the respondent in contempt of complying with the said judgment and by the provisions of Section 36, 2B, Section 240, 243, 254C, 5, sub 6 of the National Constitution, and the case of Skybank and EU, citation supplied, it is clear that the decision of the National Industrial Court is appealable, but with the leave of the Court of Appeal, there's no reference to fundamental rights violation to guarantee an appeal as of right to the respondent in the instance case. Counsel also submitted that from the entirety of the procedures filed before this court and the Court of Appeal, the respondents have not shown before this court an order of the Court of Appeal granting leave to them to take any step or file notice of appeal in this suit. That all steps taken by the respondent in this suit in respect of the appeal are exercised in futility, as one cannot put something on nothing and expect it to stand. It must surely crumble, citing the case of McFoy and UAC. The other counsel submitted that the question then is whether the respondents have a subsisting notice of appeal filed on the order of the Court of Appeal. The answer is in the negative. According to counsel, the law is tried that an appeal filed after the stipulated time without leave of court is not an appeal and ought to be struck out, citing the case of Ahinauhi and Oteri. The submission of counsel that the respondents have no willingness to comply with the judgment of this court and are not diligent in pursuing any appeal. The judgment was delivered in this suit on the 18th of January 2018, and the orders contained therein were to be complied within 30 days of the judgment, and the respondents have 90 days to appeal against the judgment, but they never took any step in seeking to comply with the judgment until when the judgment creditors filed an application for committal proceedings. Counsel further submitted that it was when the judgment creditors filed the application for committal for contempt that the respondent realized to file a notice of appeal without leave of the Court of Appeal as required by the Constitution, just to guard judgment creditors from exercising their right to seek the fruit of their judgment. It was contended that it took the respondent 4 years and 5 months to file an invalid notice of appeal. Counsel submitted that if the argument of the judgment debtors or respondent is anything to go by, in terms of alleging that the inability of judgment creditors to refund judgment sums in the event that the respondents succeed on appeal, judgment sum can be paid into an interest yielding account in the name of the chief registrar of this honorable court for preserving of the sums while yielding interest in favor of the parties that succeed on appeal. It was argued that the respondents cannot, while in disobedience to the judgment of the court, and yet seek discretionary powers of the court. Another counsel submitted that the respondents having no leave of the Court of Appeal to file any process of the court in pursuit of the judgment of this court, the counter affidavit to the motion for committal is void and bereft any cogent fact in opposition to the motion for committal against the respondent. That an execution or judgment of court can only be stayed on grounds of valid and subsisting appeal. But where there's no valid appeal, then there's nothing to warrant staying the judgment. According to the applicant, the respondent's opposition to the committal proceedings, to the committal application, is to continue to delay and deny the applicant the fruit of their judgment in a commodore manner. Determining this application, I need to retrace the trajectory of this case. This case was filed in 2013 and judgment was given in favor of judgment creditors applicants against judgment debtors on the 18th of January 2018, while the respondents were ordered to comply with the judgment within 30 days. But the respondents only filed their notice of appeal at the registry of this court alongside an application for stay on the 17th of December 2018. However, the application for stay was dismissed on the 22nd of February 2022. The respondent in their opposition to the instant application filed a counter affidavit and a further affidavit and attached two different notices of appeal to the two affidavits. MPB1. I observed that the two notices of appeal attached to the respondent's counter affidavit and further affidavit were filed at the registry of this honorable court on the 21st of June 2022 and 17th of December 2018, respectively. I also observed that the respondents averred in their further affidavits, in their further counter affidavit, that they have filed a motion to file an appeal alongside the said notice of appeal. But what I saw attached to the further counter affidavit is an undated and uncommissioned motion for extension of time to compile and transmit record of appeal. I observed, however, that the deponent to the affidavit in support of the said motion stated that the deponent was informed about the fact averred on the 24th of June 2022. It is pertinent to state that by the provisions of Section 24 of the Court of Appeal Act, the respondents have 3 months within which to appeal a final judgment of this court if they feel dissatisfied. And once a party is outside this prescribed period, he must apply to the Court of Appeal for extension of time to give notice of appeal or notice for leave to appeal as provided by Section 24 sub 4 of the Court of Appeal Act. See the case of Mobile Oil and Adadaigo. Section 243 sub 2 and 3 and 245C 5 and 6 of the 1999 Constitution also provide that an appeal shall lie from the decision of the Court of Appeal as of right. An appeal shall lie from the decision of this court as of right to the Court of Appeal in criminal matters and on questions of fundamental rights as contained in Chapter 4 of this Constitution. And an appeal shall only lie from the decision of this court to the Court of Appeal in other civil matters with the leave of the Court of Appeal. Looking at the process presented before this court, there's no doubt that the judgment debtors respondents only filed their two notices of appeal about 11 months and or 4.5 years respectively after the delivery of judgment. But there is no any application for extension of time for leave to appeal or even an application for leave to appeal as required by Section 24 of the Court of Appeal Act. See the case of Skybank and EU. It was held in the case of Mbonu and Wakama that there is a world of difference between an application for leave and an application for extension of time to apply for leave. While the former implies a right of appeal subject to leave of court within time, the latter implies that right to appeal with leave has elapsed and is no longer extant until the court brings it to life by an extension. And until the court brings it to life, it cannot be equated to an extant right to appeal with leave. It is settled law that where the leave of the court is required for the exercise of right of appeal, obtaining such leave becomes a condition precedent to the exercise of that right of appeal, and failure to obtain leave where it is required will render the appeal incompetent, as the appellate court will be the advisor of any jurisdiction to entertain the matter. See the case of Fan and Bicotany Limited. It is clear from the above that there's not yet an appeal before the Court of Appeal, and there's not any application either for extension of time for leave to appeal or an application for leave to appeal. Therefore, the two documents attached to the respondent counter affidavit and further affidavit and notice of appeal are incompetent. By the provisions of the rules of this court, the court has inherent powers to protect itself and others and to punish for contempt any act of disobedience to its lawful orders. Order 63, sub 1, sub 1 and 2, A and B, sub 4 and 6 of the rules of this honorable court provide for committal for contempt as follows, and I quote: the power of the court to punish for contempt of court may be exercised by an order of committal. An order for committal may be made by the court where contempt of court A is committed in connection with any proceeding before the court, or B is committed in the face of the court, or consists of disobedience to an order of the court or breach of an undertaking to the court. While the court makes an order and the party affected by the order refuses, neglects, or fails to obey the order, injunction, or directive of the court may, on application, issue an order of committal for contempt. While the contemptor is not a natural person, the court or the applicant shall seek leave of the court to proceed against any of the principal officers of the contemptor, or against the chief executive officer, managing director, the company secretary, or any other responsible and highly placed officer of the contemptor on court. Section 10 of the National Industrial Court Act 2006 also provides that the court shall have the power to enforce its judgment and accordingly may commit for contempt any person. A contempt proceeding is meant to call one in disobedience to court judgment to order and to protect the integrity and sanctity of the court and ensure effective administration of justice. See the case of Alechino and A.G. Bender State. In the case of Onwaka and Adikanku, it was held that any judgment made by the court deserves and demands obedience, whether or not the judgment was well-founded. The power to punish for contempt is also constitutional, and the courts are expected to guard their powers, integrity, and decisions jealously, are ready to punish any act of disobedience or conduct that puts the court or its decision in derision or poses an affront to its being obeyed or respected. See the case of Idigbe and IGP. Why a person is in continuing disobedience of the court order and has not the least intention of complying with it, as in the instance case, it will be improper for the court to consider the exercise of discretion in his favor. In the case of Lydia, Modupe Lawal, and Osula. My intention was drawn to the fact that after this matter was adjourned for ruling, the judgment debtors filed a further and better affidavit on 21st of November 2022, attaching the compiled record of appeal and marks them as Exhibit A and B. I need to say that the said further and better affidavit seems to be incompetent, but for what it's worth, since there's not any valid appeal before the Court of Appeal upon which the said records of appeal can stand, the said records of appeal is discontinuous for the purpose of this application. Having said that, and after considering all the processes filed by the parties, I am of the opinion that the applicant's application has merit. And on that basis, an order of committal for contempt of court of this honorable court is granted. And the chairman of the Military Pension Board, who is the principal officer of the second judgment debtor respondent, is hereby committed to Correctional Center for 3 months for failure to comply with the judgment of this honorable court delivered on the 18th of January 2018 until and unless he purges himself by complying with the judgment of this court.
As the court pleases, my lord.
Yes.
I thank my lord for the well-delivered ruling. We
Thank you.
appreciate the wisdom of the court, also to stand it firm in the line of judicial powers. We are grateful to the honorable court to take
It's
further
like
steps.
it's like the claimant is in court, huh? Mr.
Yes, sir.
Atere?
Yes, sir.
First claimant is in court.
Okay.
First judgment editor.
Yes, my lord. The first judgment creditor applicant is in court. It came in the course of the ruling.
Mr. Bola.
Unmute yourself first.
Yes, my lord, we have listened to the judgment.
Yes.
We thank you for the judgment.
Thank you. I thank you too.
Yes, my lord.
But please, you should go and comply, please. Eh? It's a simple, Mr. Bola.
Sir.
The judgment creditors are citizens of this country. They have served this country. They have gotten judgment. So why the delay, please? Ask the judgment details to please comply.
Yes,
what the big deal in paying somebody that has served the country?
Has served the country. My lord.
Yes.
Off record, my lord. I have off record, my lord. I have seriously, I'm putting serious pressure that that I don't like this kind of matters.
Yes.
In fact, it's the first time that I will be involved in this. In all my 33 years in practice, I have never had a case where there will be a judgment for 4 years and nothing is done. That is a very difficult. It's a very, very difficult application for me.
Yes.
So initial fear was that won't it open a floodgate of other people now coming to say they're also entitled? And I explained that no, every case is treated on its merit. On its fact. That if something could be done about this matter, that I will be happy. So I'm putting pressure, and then I'll continue to put the pressure that this is not a matter that is worth going on.
Yes, it demoralizes the any person that's a public officer.
Oh no, yes,
it's demoralizing. It's demoralizing.
Yes, and I even told them, I even informed that before a judge that is very compassionate and simple, that a very hostile judge won't even hear me. Very hostile judge.
Please let them comply, please. How much is even the money?
We'll try.
I don't think it's much, Mr. Bola. I don't think the money is much. Is it much?
I don't. Well, we will. No matter, my lord, sir. No matter whether the money is much or not. If there is a judgment of the court, what is the? And it's an institution.
It's an institution. It's an institution.
So steps must be made to
and they can even do it secretly. They can pay them secretly without the other people knowing. Or even if somebody will come, there is this statute of limitation now. Somebody who has slept over his right, can you now come up and say yes?
My lord, it's not even. You are correct, my lord. I agree. But the fact still remains that it is not a matter in which yes, this is a precedent for which anybody can also come and be saying,
yes.
No, it will be treated on its merits. That are you entitled to it? If you are not entitled to it, you will not be given. And if you take steps, maybe if they are taking steps since 2018, maybe we will not be where we are now. People will not be where we are now. I will keep mounting the pressure because I mean our duties is not just to be saying I want to prosecute to judgment. I want to ensure that it's also
and look at the inflation. Look at the economy. It's not
My Lord will appreciate that it was a difficult case for me to even argue, and I was even commenting, my Lord. It was a difficult case to argue. It's so open, my Lord. I'm saying it open.
Yes.
I mean, it's such a matter
No,
that
I appreciate that.
We will ensure at least we will press for the enforcement, at least so that seeing how my Lordship's mind is working, we will press for the enforcement so that at least there will be no noise about the committers prison and all that stuff. No, but we will press for the enforcement that please quickly let us do this thing. And my own integrity is also on the line, and if I have gone that far, I will definitely, put my own observation in writing. But I know that verily, I know that they will comply. I know they will comply because we've been putting pressures. They will comply.
Okay. Thank you so much.
Thank you, my Lord, for your understanding, sir.
Thank you so much.
Thank you, sir.
Thank you so much.
Yes, I'm grateful to my learned friend.
Thank you, Mr. Achoe.
Yes, my Lord.
Yes.
Thank you, sir. Have a nice day.
Thank you, sir.
I wish you a very good afternoon.
Thank you, sir. Thank you, my Lord.
Yes. Ajay, is that all?
Yes, my Lord. That's all for today.
So you call it a day?
Yes, my Lord.
Okay, thank you. Bye-bye.
Okay, sir.
Bye-bye.
Have a nice weekend. Thank you.
Yes, sir.
Bless you, don't finish. I watch your last.
Good afternoon, my Lord. Sorry, my laptop wasn't audible. I need to announce myself. Yes, I'm ready for my left. Thank you. Yes. Thank you. Okay, thank you.